Hi, welcome to part 2 of the video on contracts. Like I said in the earlier video, I'm going to be bringing you a lot of goodies this December period, this Christmas period. So I need you to please subscribe so that those goodies will get to you. I'm making an offer like we talked about in the first video, and it's important for you to accept it by subscribing to the channel, liking the videos, leaving me comments, sharing the link to this channel and to the videos with your friends far and wide. Very important, so that there might be, a valid contract between both of us. I'm just kidding, but please subscribe. Now let's talk about the 7 most important clauses in a contract that you should look out for. This is very important if you're a lawyer who reviews commercial contracts. These are the clauses you should be looking out for your clients. And if you're a lawyer who drafts commercial contracts, these are the 7 most important clauses that you should pay attention to. And if you're a layman too and you enter into a commercial agreement, you should look out for these clauses. And if you're a law student, you know that you definitely need this knowledge on the law of contracts. So let's get right into it. The first clause I want to talk about today is the confidentiality clause. The confidentiality clause. The confidentiality clause is that clause that allows you to state that the contract is confidential, and under no circumstances should any party divulge the information contained in the contract without permission or even to anyone or any third party. So that clause makes it illegal for any party to share the contract with a third party. This is very important to protect your intellectual property for contracts that involve IP, and it's also important to protect business interests, trade secrets, and all manner of valuables that are involved in the contract. So the confidentiality clause, that clause must expressly outlaw sharing the contract, with just anybody or just with a third party. So it's important. The second clause that I want to talk about is the force majeure clause. Force majeure, as the name implies, force majeure, major force or mighty force. It's also called an act of God. It's a clause, that I saw that it gained a lot of traction during the COVID-19 lockdown in 2020, and it's a clause that has always been, but I just saw that it gained a lot of significance and popularity, especially in Nigeria during the COVID-19 lockdown. The force majeure clause is that clause that helps you or allows you to be able to say that, in the event of an act of God, this contract is no longer in force, or this part of the contract will be waived or overlooked or cannot be performed, or this person will not be held liable. For instance, in the event of an earthquake now on a farmland, you could say that in the event of an earthquake on the farmland where so and so crops are cultivated, the crops being the object of the contract, because you're supplying the other party agricultural produce. For instance, you could say something like, in the event of an earthquake that destroys the object of this contract, this party will not be held liable, because that act is an act of God. That act, goes beyond their power. Terrorism can also be an act of God. COVID-19 is also a force majeure. There could be so many things that count as force majeure. So when such things happen, it will be left to the courts, to the lawyers, to interpret what force majeure is, the scope of it, depending on the laws and decided cases, and to decide if a party is excusable because of force majeure. So force majeure clause is a very important clause. You should put it, because no one knows the future. The third clause that I want to talk about today is the warranties and covenants. The warranties and covenants clause. That's the important clause where parties covenant to do one thing or the other, or to waive one thing or the other, or not to do one thing or the other in the event of one situation or the other. For instance, in a tenancy agreement, the landlord covenants to do certain things, to deliver the property up in tenantable condition, to pay the government levies and accruing rates and charges on the property, to make major repairs to damages on the property, to do this and that. And then the tenant also covenants to keep the property in tenantable condition, to keep it clean, to pay domestic rates and charges, such as maybe waste disposal rates, NEPA bill, utility bills, and what have you, and some other covenants. So that clause is very important. You should pay adequate attention to it to ensure that you're not covenanting or guaranteeing to do something that you will not be able to do in the long run, and to ensure that you're not being shortchanged with the responsibilities that you're taking on, or the things that you're waiving, the rights or the rights that you're waiving in the contract. So it's important, pay attention to the warranties clause or the covenants clause. The next clause that I want to talk about, the fourth clause, is default or damages clause. So it's different from force majeure because that clause is talking especially about defaulters and about damages. So it says that, okay, in the event that party A is unable to perform their part of the contract, they will pay so amount to party B as damages. In the event that party B is unable to perform this part of their contract, they will pay so as damages in lieu of the performance of the contract. So it's important to put this because, you know, although the terms of a contract must be certain, sometimes there are things that happen that are beyond human ability or human control, which makes one party or the other unable to perform. I'm not talking about acts of God now. I'm talking about, you know, probably unforeseen circumstances or willful refusal to perform. Now, this clause is important because it precludes a party from taking the other party for granted and saying, oh, if I don't do it, you're not going to do anything. Now, that's different from even suing or doing anything. We're talking about when there's non-performance by a party, what is the remedy that's been factored into the contract. It's very important for you to factor in those remedies aside, you know, enforcing the contract in court or doing one other thing or the other. It's important for you to include a damages or a default clause that, okay, if you don't pay, if the contract is a loan repayment contract, for instance, you could say that, oh, if party A fails to pay, you know, this they are due. If party A fails to pay so installment after this date, they are liable to pay, you know, damages or penalties. Maybe they will pay double interest. So you could say in a loan repayment contract, for instance, that if party A refuses or fails to pay their due installment before or after so date, they are liable to pay double interest. They are liable to pay in default so amount of money. So I hope you understand it now. The default or damages clause. This clause helps to enforce the contract because it strengthens, you know, the liability and the hold of the contract and the hold of the duty to perform on each party. So it's very important. The next clause that I want to talk about is the jurisdiction clause. Very important. Jurisdiction is the clause where you talk about choice of law and choice of forum. Now, this is more in the realm of private international law, but it's also applicable to all aspects of our life. So even if you're not a lawyer, you should understand it. Choice of law is the law that parties have chosen will govern their transaction, and choice of forum is the courts that the parties have chosen will govern their transaction. For instance, you would notice that Google clauses. I often use this example because it's the easiest. Google clauses, if you look at the choice of law and choice of forum for Google, you'll see that if you have any dispute with Google, you have to go to California in the US. So the choice of law is the United States law, particularly the Californian law, and of course the court will be in California. So you have to go there. So parties need to state it in their laws. Okay, we're in Nigeria, we're executing this contract here. Of course, there are certain operations of the law that come in automatically where there's no choice of law and choice of jurisdiction stated by the parties. So for instance, the law of the place where the contract was executed will come into force where this is absent, or the law of the place where the contract is performed, part performed, or is supposed to be performed will come into place. But if you want to excuse all these automatic legal implications, you can expressly state your own jurisdiction in the contract. You say something like, if any dispute arises from this contract, we will subject ourselves to the High Court of Lagos State or the High Court of Ogun State and the Ogun State law on property transactions, the Ogun State law on shipping, the Ogun State law on this or that will govern our transaction. I'm just using those examples. So it's important for you to delineate the jurisdiction in your contract. That's the jurisdiction clause. Then we have the termination clause. This clause is very important. As a labor lawyer, I know that in labor disputes, termination clauses are the most tricky clauses and the clauses that gets most employers in trouble a lot, because there are stipulated modes of termination in each contract. Most employers are always in a hurry to dismiss, an employee, and so they always fall short of termination clauses. So it's important for you to include a termination clause in your agreements, in your contracts, and it's important for you to pay close attention so that it doesn't, work against you. So termination clause is the clause that shows you how legal relations between both parties can come to an end. So it will show you that, in the event that this employee in a contract of employment, for instance, it will tell you that, okay, if this employee commits fraud, so type of fraud, and is caught subject to a panel and is found guilty, they are terminated. Their employment is terminated. Or it will show you that, okay, if this party does not perform their part of the contract up until so date, this contract is terminated. Or it will show you that, if so and so does not happen or happens, or if this party does this or does not do this, then the contract is terminated. So it will expressly state how you can terminate the contract. Sometimes if the contractual relation is governed by a statutory body, there are statutory provisions that would come in play regardless of whatever is in the contract of employment. So you need to pay attention to that. How are contracts in such sector or under such statutory bodies terminated? You need to look at that. But essentially, the termination clause must give regard to existing law and must give regard to due process, because it might come back to bite you. So when you're entering into a contract, for instance, a tenancy agreement, how will the tenancy be terminated? By giving 1 month notice, by giving 6 months notice, either by the landlord or by the tenant. Or you could say the landlord is entitled to give just 3 months notice, the tenant is entitled to give 6 months notice. If this is absent in your tenancy agreement, the law will come in place, and the law is that a yearly tenant, you have to give them 6 months notice, and they are entitled to 6 months notice. The same thing with contracts of employment. You have to make sure that your termination clause is not running foul of any pre-existing statutory provision or law, because it might work against you if a party decides to go to court on that basis. But essentially, you need a termination clause in your contract to state how you can determine legal relations, how both parties can determine legal relations. And the last clause that I want to talk about today is the ADR clause. I saved the best for the last because I am an ADR specialist, a mediator to be precise. So you need to put an ADR clause in your contract, especially your commercial contracts, because of course we know that litigation is the way to enforce a contract. But you could also put an ADR clause and say that in the event of a dispute in this clause, parties will be subject to the Lagos State Multi-Door Courthouse to attempt peaceful, amicable, alternative dispute resolution. Or you could say that, parties will submit themselves to arbitration first before any other litigation option is pursued. So if you say something like that, it means that if there's a dispute, a party cannot just run to court. They have to explore arbitration first. You could even spell out how the arbitrator will be appointed in your contract, who will appoint the arbitrator, who will pay for the arbitration, and all of that. So the ADR clause. Now, the supervening clause is the dispute resolution clause. But under it, you have ADR, you have litigation. So that's why I just said ADR. But it's a dispute resolution clause. That's the 7th clause. That's the clause that states how disputes arising from the contract are going to be performed. But instead of putting just litigation, which everybody knows and which is like, the way to go, a better way to go is ADR. So you put ADR first. These days, it's encouraged, it's the practice now. And then you now put, in the event that they cannot settle by ADR, then they can go to court, and then you put choice of forum, choice of law governing the dispute. So these are the important clauses that you should include in your contract so that you can be safe and secure and to avoid stories that touch the heart. That's all I have for you in this video. I will always see you in my very next video. Don't forget to subscribe. Toodles.